Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 9 subsection 1 clause 7 which talks about income by way of fees for technical services, where the role of the assessee is to provide a platform to the Indian subscriber to come to their website and post their advertisement, and this is in the nature of a standard facility. So whether this platform of e-commerce of providing a platform for posting the advertisement on the website comes into the definition of fees for technical services according to section 9 subsection 1 clause 7. This issue was decided by Bombay High Court in the case of Commissioner of Income Tax International Taxation versus Alibaba.com Singapore E-Commerce Private Limited. This case has been reported in 459 ITR at page number 508. The matter has been decided on 16th June 2023. In this case, there was deliberation on the word fees for technical services. As all we know, this word fees for technical services is a word which becomes the sandwich between the two words, that is management and consultancy. It is a trite law that for management services, there should be human interaction, and without the human involvement, there cannot be management services. Same is the case with consultancy. Only the human, which have the perfect knowledge, which have the expert knowledge, can provide the consultancy. So, the fees for technical services which comes in the middle of management and consultancy also takes the color from these two words, and without the human interaction, it cannot be said that the fees for technical services is there. In the present case, during the assessment proceedings, before the assessing officer, the assessee submitted the certificate of incorporation and tax residency certificate provided by the Singapore authorities, but the assessing officer denied this certificate of incorporation and tax residency certificate, and ultimately denied the benefit of double taxation avoidance agreement between India and Singapore, and held that the facilities which have been given by the assessee on its web portal by providing the advertisement for the Indian subscribers and whatever the payment the assessee is receiving from the Indian subscriber is taxable as fees for technical services. When the matter was before the dispute resolution panel, the dispute resolution panel said that the assessee is working through dependent agent permanent establishment, that is F, and in the present case the assessee income is taxable as business income and not as fees for technical services. In other words, there was the dispute, or there was change of opinion, or there was difference of opinion between the dispute resolution panel and the assessing officer. So the assessee was before the tribunal. The tribunal said that in the present case, since there is a standard facility provided by the assessee through the e-commerce operator, and the assessee is getting the payment from the Indian subscriber for advertisement on the web portal, so it can be safely said that there is no human services provided. There is not much human services provided, and whatever the services the assessee is providing does not come into human services and ultimately into the fees for technical services. So the first point which the assessing officer was saying, that this is fees for technical services, the tribunal denied that thing. And the second issue which the DRP was saying, that the assessee is working through a dependent agent permanent establishment, for that the tribunal said that in the present facts and circumstances, the agent is not dependent agent permanent establishment but is an independent agent, and it cannot be said that in the absence of permanent establishment that the assessee has business income in India. So in the present facts and circumstances, the assessee income as per tribunal is not taxable either as fees for technical services or as business income. When the department carried this matter to the Bombay High Court, the Bombay High Court has the same view as the tribunal and said that the assessee income is not taxable either as business income or as fees for technical services. Friends, this case is very important as far as the understanding of fees for technical services is concerned, one should read the full judgment before relying on this judgment. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax International Taxation versus Alibaba.com Singapore E-Commerce Private Limited. And this case has been reported in 459 ITR at page number 508. And the matter has been decided by Honorable Bombay High Court. And the date of the judgment is 16th June 2023. Thank you, friends.